Who must be joined as parties in a foreclosure action? That was the question in the case of the bank, the debtor, and the judgment creditor. In this case, Peters obtained a default judgment of over $24,000 against a company known as Barker and Little Inc., which managed rental properties. The company was a general partner of a limited partnership, which had been extended a full line of credit by the bank, secured by the mobile homes and rent-to-own contracts it held. The companies were owned by Hamilton. The bank initiated foreclosure proceedings against the companies in 2008 and named the companies as defendants in each of its actions. Later, the bank and Hamilton privately negotiated a settlement agreement under which the various entities transferred real and personal property to the bank. The bank did not join Peters as a defendant or otherwise notify her of the foreclosure actions. Upon learning of the bank's foreclosure actions involving Barker and Little, Peters sued the bank, alleging fraud, conversion, deceit, and unjust enrichment, alleging she had a superior claim and that she should have been named in the suit as an interested party. The bank claimed that Peters was not required to be joined as a defendant in the foreclosure actions against the entities. South Dakota law provides that a foreclosure plaintiff must join as a defendant those who have an interest in or lien on the mortgage property as of the date of filing the action. How would you decide this case? Did Peters have an interest in the property secured by the bank, and should she have been made a party to the foreclosure suit? We'll be back in a moment with the answer. Did Peters, the judgment creditor, have an interest in the property included in the bank foreclosure actions as of the date the bank filed those actions? No, was the South Dakota Supreme Court's answer. The court used rules of statutory construction to determine the meaning of interest as it was used in the foreclosure law. While there was no doubt that Peters desired access to the foreclosure property in order to satisfy her judgment, her desire did not equate to an interest as that term is used in the law. Peters did not have an interest in the foreclosure property, that is, she did not purport to hold any present or future estate in or option to purchase the foreclosed property. Instead, she had merely obtained a default money judgment. Such a judgment did not in itself give Peters the right to Barker and Little's property. The trial court's entry of summary judgment in favor of the bank was therefore affirmed. Remember, it's a matter of law.